I'm just going to go through some of the key points over here. This is one of the most anticipated judgments or orders of the Supreme Court of India. It concerns the Hindenburg case, a series of allegations made several months back against the Adani Group by the short seller, the Hindenburg Group. The Supreme Court has quite categorically rejected the arguments which have been made in the Hindenburg report by the petitioners, making it absolutely clear that referring to third-party organizations is not something that is going to work in the absence of substantive evidence or substantive proof that, yes, inputs can be taken from third-party organizations, but when it actually comes to having merit in the courts, they need to be substantive or they essentially get rejected. That's what has taken place today. I'm going to go through the key aspects of the Adani-Hindenburg judgment. The Chief Justice, reading out the conclusion, said that the power of the Supreme Court to enter into the regulatory framework of SEBI is limited, number one. In other words, the Supreme Court says, because a lot of allegations had been made on the role of SEBI, whether SEBI's analysis or its own interpretation of the allegations in this case was independent or not, the Supreme Court backing SEBI and saying that they cannot enter into the regulatory framework of SEBI. They have a limited ability to do that, and in this case, as you will see, they have chosen not to do so. The Supreme Court says that there are no valid grounds raised to direct SEBI to revoke specific amendments, and that the regulations in question, LODR and FPI, do not suffer from any infirmities. Number three, SEBI has said that there are 22 grounds on which Hindenburg was being investigated. The Supreme Court has said that there were 22 grounds in which SEBI was investigating Hindenburg. 20 of those have been addressed. There are two final areas which SEBI needs to look at. The Supreme Court has passed an order telling SEBI to complete its investigation into the other two cases within 3 months. Just on this one point, Sunil, is it likely that the Supreme Court will come back after 3 or 4 months once SEBI presents, I presume, a report on the remaining two areas that it's looking at?
Very unlikely. I mean, of course, there is always that possibility. But the fact of the matter is, I think somewhere down the line, this is a clean to the entire Adani Group. Of course, NDTV is part of that. And it's in that backdrop that certain steps will have to be taken. So it's definitely a big reprieve and making it clear, as you rightly pointed out, not to rely on reliance of, they call newspaper reports, asking SEBI and the government of India to take whatever necessary action that is required to look at this in its entirety.
All right, I'm just going to go through a few other points which the court has also mentioned. The Supreme Court holds that there is no ground to transfer this entire investigation to an SIT. This was one of the key demands which was made. The petitioner, Sunil, as I understand it, questioned the credibility of SEBI, questioned the credibility of the special panel which had been made by the Supreme Court as well, and they had demanded an SIT, the court saying that no SIT, right?
That's right. They have ruled out the possibility of a special investigating team. That was one of the points with the petitioner. The solicitor on behalf of the government of India in the last argument had explained and shown the linkage between the ORCCP report as well as, petitioners saying that this is not something that is good. And clearly, it's in that line of focus that the Supreme Court has said that we can't have a roving investigation. They haven't used that word, but definitely these are certain aspects that need to be looked at. And with the government, with the Supreme Court now giving it back to the government of India and SEBI to take whatever is to be done to ensure, Vishnu, it's a much bigger. It is the Adani Group. Tomorrow it can be any other group. And I think that was uppermost in the minds of the Supreme Court to ensure that nobody should suffer from a short seller, Hindenburg kind of report in future. To ensure that there are certain safeguards because it has long-term implications for the Indian markets, for the small investors and others. And that's, I think, the primacy and concern. And it's in this context that the reports that have come, the judgment that has come, gives a virtual clean sheet to the Adani Group,
Yes.
and makes it clear that whatever SEBI has been doing has been in accordance with law and has ruled out that special investigating team.
Sunil, just going through what we've been discussing now for the last 15 odd minutes or so, as I see it, there are three conclusions. Number one, there is a clean chit on the basis of this order to the Adani Group. Number two, there is strong mention of the need to protect the interest of small investors in this country. And number three, institutions need to be protected unless there is credible information to suggest that they aren't functioning. In this case, there is nothing to suggest that SEBI isn't doing its job. Would you agree that these are perhaps the three key points here?
I would say these are the three key points, and also add to say that don't rely completely on newspaper reports. There has to be substantial proof. There has to be evidence. It can be a point, but it cannot be the sole reason for why an investigation should be done. I mean, various points, the DRI probe, everything have been, very, very categorically pointed out in that entire judgment of the Supreme Court in the order that has been passed. So definitely, the Supreme Court, when its suo motu took this entire portion, made it clear. And especially when there was a public litigation that had really started this entire ball rolling, decided to issue notices, have said that it has been brought to really bring out certain issues. In this case, what has been attempted to be done.
All right, Sunil, we've lost that audio with you. We'll come back to you.